Glory, America, bonjour, hi, Canada, Hugh Hewitt. Thank you for listening to the show today. The United States House of Representatives will take up and consider an article of impeachment against President Trump today. It is very, very ill-advised. I know that one of the people I respect the most in the Congress, Liz Cheney, is going to vote yes. I wish she would reconsider. It is ill-advised because it is unconstitutional to try a president who has left office. This is an op-ed, a column in the Washington Post posted yesterday afternoon by J. Michael Luttig. Judge Luttig served as a judge on the United States Court of Appeals for the Fourth Circuit from 1991 to 2006. He was, along with Chief Justice John Roberts, the two men considered by President George W. Bush to replace Justice Rehnquist as Chief Justice. They were both judges at the time. Not long thereafter, Judge Luttig left the bench, became a much respected general counsel and vice president of Boeing. He is now in retirement and wrote this piece. He rarely writes, but he writes on big legal issues, often for the Washington Post. I think you need to read it. I have tweeted it, and this is what it said. It appears, writes Judge Luttig, that even if the House of Representatives impeaches President Trump this week, the Senate trial on that impeachment will not begin until Trump has left office, and President-elect Biden has become president on January 20th. That Senate trial would be unconstitutional. On Sunday, House Majority Whip James Clyburn said that while House Democrats would take up articles of impeachment this week against President Trump, the House might delay sending the Senate any articles passed by the House until after President-elect Biden's first 100 days in office. Biden proposed an alternative, under which the new Senate would begin immediately working on his legislative agenda and confirming his cabinet appointments in the mornings and conduct the impeachment trial in the afternoon. The sequencing of the House impeachment proceedings before Trump's departure from office and the inauguration of the new president, followed by a Senate impeachment trial perhaps a month later, raises the question of whether a former president can be impeached after he leaves office. The Constitution itself answers this question clearly. No, he cannot be. Once Trump's term ends on January 20th, Congress loses its constitutional authority to continue impeachment proceedings against him, even if the House has already approved articles of impeachment. Therefore, if the House of Representatives were to impeach the president before he leaves office, the Senate could not thereafter convict the former president and disqualify him under the Constitution from future office. The reason for this is found in the Constitution itself. Trump would no longer be incumbent in the office of President of the United States at the time the delayed Senate proceeding and would no longer be subject to impeachment conviction, that's in quotes, by the Senate, under the Constitution's impeachment clauses, which is to say that the Senate's only power under the Constitution is to convict or not an incumbent president. The purpose, text, and structure of the Constitution's impeachment clauses confirm this intuitive and common sense understanding. The very concept of constitutional impeachment presupposes the impeachment, conviction, and removal of a president who is, at the time of his impeachment, an incumbent in the office from which he is removed. Indeed, that was the purpose of the impeachment power, to remove from office a president or other civil official before he could further harm the nation from the office he then occupies. The plain text of the Constitution's several impeachment clauses confirm this understanding of this limit on Congress's impeachment power. For example, Article 2, Section 4 of the Constitution reads, quote, "The President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors." In the same constitutional vein, Article 1, Section 3 provides in relevant part, "Judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States." It has been suggested that the Senate could proceed to try the former president and convict him in an effort to disqualify him from holding public office in the future. This is incorrect because it is a constitutional impeachment of a president that authorizes his constitutional disqualification. If the president has not been constitutionally impeached, then the Senate is without the constitutional power to disqualify him from office. I repeat, If a president has not been constitutionally impeached, then the Senate is without the constitutional power to disqualify him from office. Some constitutional scholars take support for their view that the Congress can impeach a former president from two instances in which early Congresses impeached civil officials after they had resigned their public offices: the impeachments of Senator William Blount in 1797 and the impeachment of U.S. Secretary of War William Belknap in 1876. These congressional impeachment cases provide some backing for the argument that Congress can conclude that it has the power under the Constitution to impeach a former president. And Congress's understanding of its constitutional powers would be a weighty consideration in the ultimate determination whether the Congress does possess such authority. When and if the former president goes to court to challenge his impeachment trial as unconstitutional, Congress is sure to make its argument is based on these congressional precedents, as well as others, a case that would almost certainly make its way to the Supreme Court. In the end, though, only the Supreme Court can answer the question of whether the Congress can impeach a president who has left office prior to its attempted impeachment of him. It is highly unlikely the Supreme Court would yield to Congress's view that it has the power to impeach a president who is no longer in office when the Constitution itself is so clear that it does not. Judge J. Michael Luttig. It is a disaster to do this. If you are a Trump opponent, do you not understand that when President Trump brings his inevitable lawsuit against the constitutionality of the impeachment proceeding trial against him in the Senate, and he wins, what that will appear to do? It will appear to exonerate him. Think about that. Donald Trump is going to sue to stop the impeachment trial because he should sue. It's unconstitutional. And I would not have voted for the October 6th objections. I wrote that before they occurred. I would not have done it. I would not have signed my name to it. If I had signed my name to it, I would have changed my mind after the attack on the Congress. By the way, more than 130 arrests have occurred, and more are coming. And if you were involved in being in the Capitol, you ought to retain criminal counsel and then have your counsel contact the FBI and have them arrange for your interview and possible charging and then your defense. Don't speak to the police yourself. Don't speak to the FBI yourself. Hire a criminal counsel and turn yourself in. They are going to find you. They're going to find everybody. It was an attack on the Constitution of the United States. It was. And you're likely guilty. There may be a couple of you who were swept along by the mob and forced just inside the building and left immediately. You might not be guilty. You might lack the requisite intent. But President Trump lacked the intent, as far as I can see, and as people have testified, and as the speech suggests, to be convicted of incitement, though people are going to impeach him today out of anger. Liz Cheney said he summoned the mob. He summoned a demonstration. He did not summon the mob. He summoned, in his mind, I believe, a great vast circling of the Capitol and a chanting, which is perfectly constitutional. The violence is unconstitutional. The crossing of the line is unconstitutional. It was an attack, a seditious insurrection, and it is one of the most serious things that's ever happened in the United States, and everyone who did it needs to be prosecuted. My gosh, we came close to having people murdered beyond the one police officer who was murdered. It was as close as 9/11 to destroying the Article I branch. But the impeachment ought not to proceed. It could have proceeded had it happened in the summer. Could have proceeded any other time, but not after a president leaves office. I've tweeted out Judge Luttig's essay. You can find him at Hugh Hewitt on Twitter. What do you think? 1-800-520